Hello and welcome to today's masterclass on employment issues. I'm Martin Chitty. I'm a partner in the Employment and Equalities team at Wragge Lawrence Graham Co, and I've been practicing in the employment field now for more than 25 years. The Queen's speech today has made clear that there is going to be legislation brought forward by the government changing the process of strike action ballots. And what's been said is that these changes are going to apply not in the public sector in a general sense, but into sectors in relation to education, transport and health. But obviously if you take those main sections together, they are the public sector. They are going to make a requirement that 40% of those who could vote do vote in favour, and that there's an overall majority in favour. The recent examples of strikes in the rail and transport sector, where there's only been support of about 10% of the membership, will be a thing of the past, not only because the legislation will require that, but also because that's what the union membership themselves will want to be seen to be doing. From most practitioners' points of view, employment and the Human Rights Act have an interface, but it's not a very clear interface because the Human Rights Act is really a public law concept. But for some employers it will happen from time to time. And the area where we've seen it most commonly is in relation to areas of discrimination. The expectation that legislation would be coming forward to repeal the Human Rights Act had built up, I think, in the public's mind. But what's been made clear today is slightly surprising, I think, which is that that is not what is going to happen. So there is no proposal to repeal, there is a proposal to bring forward proposals to reform the Human Rights Act. It's been made clear that there is going to be a referendum on whether we should remain a member of the European Union or not. The impact were that referendum to result in a no vote, so that we withdraw from the EU, in employment terms would be very, very significant. Most of the socially progressive legislation we've seen in the last 30 years has its origins in Europe. So to go from where we are today to a position where none of that legislation applied at all would obviously be a massive change. The Queen's speech today did touch on a number of other areas which are likely to become of interest to employment practitioners and their clients. The first of these issues is the stated intention to freeze tax and national insurance for the period of the Parliament, so for 5 years. The second point to consider is the impact of the stated intention to take those working on national minimum wage up to 30 hours a week out of income tax. The next point to consider is the proposed change in relation to immigration. So the Queen's speech has made passing reference to two possible changes. The first is that employment agencies will not be allowed to advertise only outside the UK when they're looking to fill roles. The second issue is that it appears to be the case that the government is going to bring in a greater levy on employers in terms of visa costs. Reference was made to the fact that legislation will be introduced to reduce the burden on small businesses, but it's not entirely clear what that is likely to be. Now, this has caused quite a lot of speculation. Towards the end of the last Parliament, in March in fact, some new legislation came through which has a considerable impact in the employment field. The first of the issues to talk about is the legislation introduced in March, effective yesterday, 26th of May, about limitations on the use of 0 hours contracts and specifically the elimination of exclusivity clauses. Two further areas that the Small Business and Enterprise Act brought into force in March related to penalties on employers for non-compliance. The first relates to failure to adhere to national minimum wage obligations. So the penalty which you will suffer as an employer if you don't do that will be increased. And secondly is a provision in relation to those who get on the wrong side of the employment tribunal.